Wolf Theis Soundshot. Insights and analysis from one of the leading law firms in Central, Eastern and Southeastern Europe.
Hello and welcome to a new episode of our Wolf Theis Soundshot podcast. My name is Stefan Riegler. I head the firm's disputes practice, and today's topic is careers in international arbitration. We chose that topic because international arbitration for some time now has been of key interest to the younger generation, students, lawyers starting out to make a career on a global scene. Presumably, exactly this aspect, being able to work on a truly international level, is the main driver for international arbitration, being that, for lack of a better term, popular amongst our younger colleagues. Particularly, we chose that topic against the backdrop of the forthcoming oral arguments of the 31st Willem C Vis International Arbitration Moot Court, which will take place in Vienna from 22nd to 28th March. This year's arbitration is governed by the ICC Arbitration Rules 2021. And with this, let me introduce our two guests for this episode. Let me say upfront how privileged we are to have Claudia Salomon and Stefan Kröll with us, two stars in international arbitration who are particularly equipped to talk about careers in international arbitration. And only in the interest of time, I'll be brief with introducing Claudia and Stefan. Claudia Salomon is recognized as one of the leading arbitration practitioners of her generation, both as counsel and as arbitrator. Already in 2006, I believe, GAR recognized her on its 45 under 45 list of leading practitioners worldwide. She was practicing in global law firms such as Latham and Watkins, where she was also the global co-chair of the international arbitration practice. And most particularly, in July 2021, Claudia became the first female president of the ICC International Court of Arbitration. Stefan Kröll, also recognized already in GAR's 45 under 45 edition of 2006, is, as we know, one of the most in-demand arbitrators from Germany. He is a professor for international dispute resolution at Bucerius Law School, the director of its Center for International Dispute Resolution. He currently serves as the chairman of the board of directors of the German Institution of Arbitration, the DIS, and most particularly, Stefan Kröll is the director of the Willem C Vis Arbitration Moot in Vienna. So, welcome to both of you. Thank you very much for doing this. Let me start by asking both of you about your personal story. How, and also maybe why, did you end up, if I may say, in arbitration, and how much of that was actually planned and how much of that was maybe just to some extent a coincidence?
Well, thank you so much, Stefan. So glad to be on this podcast with you and with Stefan. And thank you so much to Wolf Theis for hosting us. How did I end up in arbitration? I did not study international arbitration in law school. I began doing general commercial litigation, actually with a focus on work for cities and towns. But life takes you in funny directions. And my husband went to graduate school in Phoenix, Arizona, of all places. And so I decided to interview and try to find a job there. And the head of litigation at then Squire Sanders in 1998, in my interview, said to me that international arbitration was the wave of the future. Basically, as there was going to be more cross-border trade, there would necessarily be more cross-border disputes, and parties would use international arbitration for all the reasons we know. And that all made sense to me. So instead of trying to replicate everything that I had done to that point as a mid-level associate, I took the opportunity to be part of the energy of building the international arbitration practice there and getting as much experience as I could while still doing commercial litigation. And then the quick element is that in 2001, I had the opportunity to go to Prague in the Czech Republic because the firm had been hired to represent the country in a $1 billion investment treaty arbitration. And that really was the turning point for my career.
Thank you, Stefan.
As a German, normally everything is planned, but it's also for me, it's kind of gradual development. When I decided to study law, I always wanted to do something international. And so I spent 1 year during my studies in Geneva and had the privilege of listening to the Conflict of Law lecture by Pierre Lalive. So that's where it all started. Coming back to Germany, I started working for Karl-Heinz Böckstiegel at his institute. And that was the second big name at the time in arbitration. Wrote a seminar on the topic, liked it so much that after my graduation, I started writing a PhD on contract adaptation through arbitral tribunals, which at the time was a topic where you had different approaches in the civil law world, in particular Germany and the UK. And then also to deal with the comparative part, I did an LLM in London, met Julian Liu there, and also by pure chance, he was lecturing there. We got to know each other. I started working for him for a short period of time, went through his library to finalize my work, and then returning to Germany, finished my PhD, and suddenly, gradually, due to the contacts I had, to the publications I had made on that, I was apparently on the radar of the DIS, and then got the first appointments by them, smaller cases. And I don't know whether that helped at least. Since I was writing my habilitation at the time, I always made sure that I had a limited amount of cases. So I turned down a number of cases at an early stage. And apparently that gave others the impression he must have so many cases that he's turning down cases. And that's how it slowly developed. It was not really planned. I always enjoyed the topic. I'm teaching it now since nearly 30 years, and I still find it a fascinating topic. It was an excellent choice, I would say.
Well, of course, later on, we'll discuss what might be helpful or what are must-haves to have an international arbitration nowadays. But looking back at that time when you started out, how difficult was it? I mean, I do remember that we had quite some respect for the so-called older generation. You had to have the gray hair. You had to have maybe a career as an M&A partner. Also, Claudia, as a woman, how difficult was it then to start to have this career in international arbitration?
Well, I think I should kind of respond in two respects. The first is just as counsel. And I was very, very conscious that as I have worked in various parts of the world, whether that was in Prague, in the Czech Republic, or other parts of the world, I was acutely aware that women who were in country were often treated very differently than I was being treated as a foreign lawyer and coming from, at that point, the United States. And so I think we have to be very conscious that sometimes our own experiences aren't necessarily reflective of some of the challenges people face all over the world. Now, for arbitrator appointments, I think for me, the biggest challenge was actually the fact that I was in a large law firm. And I think I had probably 10 or more opportunities before I was even able to take the first appointment because of conflict. So that's part of the, ups and downs, or the positives and the limitations of being in a large firm.
Stefan, what about you?
For me, as I said, it was a little bit pure chance. Yeah, I wrote the PhD. I talked to people, and apparently Jens Bredow at the time already thought that they have to enlarge the pool of arbitrators with younger people, recommended me. Böckstiegel had recommended me, so I got fairly early first appointments and apparently didn't screw up too much. Yeah, so they kept on appointing me. And that's also something we tried to do at the institution, probably at the ICC as well as the DIS. One of the big problems of arbitration presently is that you have very few very busy arbitrators, and you have to enlarge the pool to younger colleagues, and that's what Bredow already did at the time. I know that at the time I was one of the few ones without gray hairs being involved.
You still don't have gray hair, Stefan?
I've lost hairs, so everything which is gray is removed. No, so for me it was, as I said, it was being at the right place with the right people. And that's what I always tell my students when they appoint someone. You can be sure that if you get someone young, they will read the case 3 times. And it's their first appointment. They will spend a lot of time on that. So take the risk. And I'm glad that some people took the risk at the time already.
It's interesting what you said, because as a board member of VIAC, I can say that we also, of course, look for opportunities to get younger colleagues into arbitrators nominations, to get them their first nomination. And I presume, Claudia, the same is true for the ICC?
Certainly, we do give lawyers who have never had experience serving as arbitrators, or people not only lawyers, to get their first appointment from the institution. And I believe globally, most people do get their first appointments from institutions. And so what we would be looking for somebody for a first appointment would be somebody who has good experience as counsel in ICC cases, or somebody who has served as an arbitrator under other rules, and somebody then we would believe could handle an ICC case. We've really got to make sure that the experience level is commensurate with the case. So if something is highly complicated with high value amounts in dispute with particular issues that are going to arise, then we're going to really be looking for somebody with significant experience. That's what the parties would be expecting in an appointment from the institution. I know we're going to speak quite a bit about tips, but one thing I would say to any young people listening, or regardless of age, people who are in the early stages of their career, is to not focus on trying to get arbitrator appointments, but instead really focus on being known as excellent lawyer, and actually being an excellent lawyer, getting your experience as counsel. Because at the end of the day, when institutions or parties are looking for arbitrators, they're not just looking for somebody who understands arbitration. They want somebody who understands if the case is commercial, who understands commercial disputes. If the case involves energy, somebody who understands energy related disputes. If the case involves construction or IP, somebody with that requisite experience. And so from my perspective, the rush in some ways to get those appointments early on is missing out. And I don't believe people are going to be perceived as the types of people necessarily that would be amazing arbitrators without, solid experience.
I would personally completely agree with that. I do see that younger colleagues often are very keen to get their first appointment, to act as counsel very quickly, do the opening statement, do the cross-examination. And I think back at my early years, exactly what you just said, Claudia, that sometimes it makes sense to have drafted an agreement, to have been active in the substantive laws in the areas that are then the subject matter of the arbitration, because the arbitration, of course, is very heavy on procedure and specifics, but there is an underlying dispute and an underlying substantive law that needs to be understood. Let's move on to another topic. Let's talk about the moot. Actually, I was a mootee in the 1990s. Arguably not the most successful one, but I was there. And I have really very fond memories from that time. And the moot for me really was the kickoff professionally. It all started with that. I met so many people in the area of arbitration, ended up writing my PhD thesis on arbitration. It eventually brought me to London to study arbitration at the School of International Arbitration and so forth. Let's talk about the moot a little bit and what it has become after all these years. Stefan, you as the director of this phenomenal event, I don't want to say competition, when and how did you first get involved in the moot?
I got involved first as the coach of the Cologne team in 1997. When I was a student, the moot didn't exist, and it was just the Jessup there. But I was always primarily interested in conflict of law, private international law, and not so much in public international law. And so that's how I got involved in the moot. And then coaching the Cologne team which was planned 2 years, it ended up 7 years. You got involved there. I had published on the topic of arbitration jointly with Julian Liu and Lucas Mistelis, a book which was then used by a lot of mooties. And so I was a permanent guest at the moot. First coaching a team, then subsequently as an arbitrator. And then Eric approached me for the first time, I think it was 2007 already, whether I could be interested in pursuing or following him if he would step down. And at that time, I was still planning to pursue a traditional career in academia, and I refused. But then subsequently, I decided that my role is not entirely in academia. I always enjoyed practice too much. So trying to find a balance there. And then I ended up being a director there. And we have, with three of us, have split up the duties a little bit. I'm responsible every year for the case, everything related to the case. And since 2012, I'm writing the case every year, thinking about the case and trying to keep people busy for 6 months, have sufficient information in. And it is really something, if you would ask me from all the jobs I had to give up, it would be the Moot, which I would keep. That is really something I thoroughly enjoy, working with the young students there and seeing how they develop. It's a pure pleasure.
Claudia, the ICC has for quite some time organized a pre-Moot. This year, the arbitration is governed by the ICC. What is the reason for the ICC actively participating in and promoting the Moot?
Well, the Moot truly is an incredible educational program that has become a global phenomenon, really attributable to Stefan and so many other people who are dedicated to the program. And why is the ICC focused on the Moot? Because for us, education and training is a key aspect of our mission as we promote, access to justice and the rule of law. And last year, we celebrated the centenary of the ICC court, 100 years since the founding of the court. And so we were particularly pleased that the ICC rules were selected for the Moot competition. When we launched the centenary at the beginning of last year, we issued a declaration, which for the listeners, if you haven't yet read that, I really encourage you to do so. It's a declaration on the future of dispute prevention and dispute resolution. And in that, we reflected briefly on our past, but also focused on the future with 10 core pledges. And one of our core pledges is indeed training and education. And another core pledge is really local engagement as we strengthen the global community. And so the Moot in Vienna and Hong Kong, with all of the teams participating, is really something we believe in and so proud to partner with.
Fantastic. Stefan, Claudia talked about the access to justice and the rule of law. Talk about how the Moot, in your view, contributes to the broader legal education and awareness of alternative dispute resolution methods.
First of all, I completely agree with Claudia. It's in the interest of not only the ICC, but all institutions to educate students and others on alternative but peaceful dispute resolution, in particular in times like this one. When I took over from Eric drafting the case, there was always a number of issues I had in mind. Eric started the whole venture as something to promote the use of text prepared by UNCITRAL, in particular the CSG at the time, but also the UNCITRAL model law. And always had also in mind the internationalization, the peaceful resolution of disputes, plus giving students an international exposure. And that's also how, in my view, the Moot contributes to education. On the one hand, substantive and procedural law, but education is much more than just learning about the law. It's learning about the values of the rule of law. It's learning about the values of peaceful dispute resolution. And it's also learning about that your approach may be one, and there may be other approaches coming from different regions of the world, which are different, but also effective. And you may, as board member of VIAC, you are pretty well aware that we have enlarged also the reach of the Moot. For probably all of us here, arbitration is a means of dispute resolution, but not the only one.
Well, I just wanted to build on what Stefan was saying in terms of the educational aspect of the moot. He made an excellent point that kind of the practice and the goal of the moot is so much more than the specific oral advocacy and written advocacy, because the practice of law is so much more than that. And so, what we hope everyone gains from the experience is also the strategic thinking, the ability and skills to develop arguments. And significantly, of course, everyone gets assessed as whether they are doing well individually. But what I love about the moot as well is that people are competing as teams. And that is, for me, the essence of practicing law and perhaps the essence of working in this modern environment, which is one success is based on the strength of the team. And so I think that's going to be really important skill that people will develop as they work to prepare.
That's an excellent point, Claudia. I do remember back when I was in Moody, in this part of the world, at least back then, during your studies at university, you were focusing on exams only. A moot court was not that common, arguing a case was not that common, and working in teams was not that common. These couple of months in the Vienna moot court team were a new experience for me, working together as a team, trying to jointly write the best written submission, to jointly prepare the best oral argument. You had to discuss, you sometimes had to fight to get to that joint position. And for me, this really was a great and very helpful experience. So I completely agree with that. Stefan, what are the other aspects you think students will take from the moot that they can translate later on in their future legal careers? Is the moot giving a flavor of an actual arbitration, or is that not even necessary?
We try to make it as real as possible. There are a number of constraints that you have to take into account if you want to put it into a moot competition. But I think students get a good feeling, and that is also something I have in mind when I draft the case. The strategy Claudia mentioned. Very often you have a problem that if you make one argument on the procedural side, it will backfire on the substantive side. So that you have to sit down with the other person dealing with the other part of the moot and find a joint strategy. It doesn't help you to win on procedure if you then lose on the merits, and it doesn't help you to win on the merits if you don't get to an arbitral tribunal, because they will never decide upon that. We try now to use the Vis case also for broader, not only arbitration, broader dispute resolution mechanisms. The CDRC in Vienna, organized by the International Bar Association and VIAC. We have at the DIS now, we invite the German arbitration teams to come after the moot and have the same case mediated, approach the same case, tell them in principle the preparation you have to do for proper mediation and for proper arbitration is largely the same. It's perhaps the mediation preparation is even more difficult because in addition to the legal side, you have to take into the commercial side and other factors which may not play such a role in an arbitration. And the other thing which I find very useful is that that's probably one of the very first or few times that in your career as a lawyer, you have really to look at one problem from both sides. You argue the same problem from both sides. That shows you that there's often not a black and white, but you can argue it both ways. And it sharpens your mind subsequently also for everything you do. Look at it from the other side and anticipate what the other side could say. And that goes back again to the strategy Claudia mentioned there. That you have in such a short period of time, you have to argue one side and then you have to argue the other side in an early stage of your career is for a lot of students mind-blowing, who came, at least from what I hear, came with the perception, okay, there is this one solution. But then you realize there may not be the one solution. It really depends how you see that particular case.
One of the other aspects people enjoy about the moot is building friendships, building a network. I personally am still in touch with some of the people I competed with or competed against, some 25 years ago. Claudia, talk about this aspect of the Moot, the friendships and the bonds amongst the Mooties.
Well, I really admire the strength of the Moot Alumni Association and how strong the bonds are among the Mooties because they feel such a wonderful connection and they want to stay connected. And just as a side note, watching the success of the Moot Alumni Association has really influenced the way I think about my work with the ICC court. And the reason I wanted to launch the alumni group for the former ICC court members, the network people have, it's not something where you have to be transactional or think about a network as something you're doing where you're maintaining a friendship or a connection because you're thinking about how it's going to benefit you in the future. You're building a network and strengthening that network because it is ultimately enriching. And if you go in with that mindset, I think you will find that it is easier and more enjoyable to want to stay connected with everyone that you are engaging with. And that's really, in my mind, something that's really at the core. Are you ultimately curious about what people are doing? Are you ultimately caring about what people are doing? And that is a way in which you can then build the network in a truly genuine way.
I completely agree. You don't build a network for your future career. You build a network because it's fun. You like the people, you're interested in the people. And these are the network which carry much stronger than just a professional network. I want to get future work from the person. And that is also one of the big targets or objectives we have with the Moot. We always ask, can we not have a virtual version, because we would have a broader reach. There's a lot of students, a lot of teams we never see. There is a decision which we review every year. And for us, that element of building connections personally is so important that we say we keep the Moot as an in-person event.
The Moot is fun. The oral arguments in Vienna are fun. It would go beyond and scope of this podcast to tell you my stories, but it is without a doubt fantastic, and you build friendships that last. So I can completely agree with that. We touched upon how to build a career in international arbitration nowadays. Let's focus on that. At some point in time, the moot is over and the so-called post-Vis moot blues kicks in. What do you do next? What advice can we give younger colleagues how they can continue to be involved in arbitration and become the next arbitration star?
Well, I would certainly encourage everyone coming out of the Moot experience to get involved with ICC's YAF, which is our Young Arbitration and ADR Forum. We have people participating from all over the world. It's our group for people below the age of 40. As people get more experience, they can also apply to be what we call a YAF representative. And we have YAF representatives from all over the world working in chapters in different regions around the world. It's a great way to continue to get speaking opportunities, to learn. If you have ideas, to see them effectuated and see opportunities to get more involved. It's a way in which you don't need to be nervous about asking questions or speaking out or making proposals because you are in an organization with your peers. And so it's really something that's dear to my heart because I was the chair of YAF when it was only in the United States. And so it's been an essential part of the development of my career. There's also lots of other ways for people to be involved in the early stages of their careers. We encourage people to write articles for the ICC bulletin. We're always looking for country reports or other things, and also to get more involved in their national committee arbitration groups.
Stefan, is there a blueprint what you have to do to have a career in arbitration? Younger colleagues sometimes asking me, do I have to participate in the moot? Do I have to do an LLM internship? What do you think are the must-haves, or is it just a very case-by-case question and you shouldn't worry too much?
I would have it halfway. Yeah. And one way, you should somehow be focused. If you're interested in arbitration, do what Claudia mentioned. Yeah. If you have participated in the moot, join the Moot Alumni Association, join the ICC YAF, or join the DIS below 40, wherever. Claudia also mentioned publish things. There's a lot of information about certain jurisdictions, but there's a lot of information missing about other jurisdictions. And if you have participated in the moot, you're probably sufficiently well equipped to write about cases in your jurisdictions, spread the news about that, and get involved in these younger organizations. On the other hand, you don't have to participate in the moot. If you're interested in arbitration, you might have the same career as Claudia, just there's an opportunity somewhere, grab it, be curious. But what arbitration always requires is an open mind, be interested in other cultures as well, yeah, and then work hard. Yeah, it's there's a famous quote by Vince Lombardi, the legendary coach of Green Bay Packers, which I always use for my lectures. Yeah, where he said the only place where success becomes before work is the dictionary. Yeah, so it's all work and then success will come. And as both of you said at the beginning, don't be too focused on, I want my first arbitrator appointments. Yeah, they may come if you have proven yourself in other areas, if you have proven yourself to being a very good counsel in M&A, understand what is going on in IP, whatever, and they will come to you. Yeah, but always keep an interest in the procedure side. I've seen so many people who are experts in post M&A, but screw up the arbitration. Yeah.
Claudia, I know we have to make, and you made that distinction between a career as an arbitrator and a career as a counsel. Having that in mind, what are the skills that one would have or to develop?
I would really focus on written advocacy and oral advocacy, but from a starting standpoint as a young lawyer, you really need to focus on your written advocacy. That means you really need to be thinking about how to be an effective writer. And these are learned skills. Sometimes people are described as natural writers or natural speakers. And I'm sure there are some people who are, but I certainly wasn't one of them. And so I am a firm believer that these are skills that can be learned and can be developed. And so that ability to zero in on an issue and develop the argument is absolutely key. Secondly, I would say as a young lawyer, you really need to be focused on the facts. If you are the person who has a mastery of the facts of a case, you will be relied upon by the senior lawyers in the case. And third, I would really urge everybody in the preparation for the moot and also as they're developing their career to zero in on what actually is at issue in the case. Sometimes we have a lot of facts. Of course we do, and lots of argument. The question is, what does the case really boil down to? What is the case about? If you have the ability to go to a movie and talk to a friend and say, I love this movie, and the person goes, oh, what was the movie about? And you are to say, the movie was about X. That's a way of also thinking about the case. The case is about X. The issue in dispute is X. And zeroing in on those is going to help shape your oral and written advocacy.
Stefan, any additional thoughts?
I completely agree. I think it's very important to be able to boil down complicated facts into what is really at issue. And that is also something you see with more and more teams, which at the beginning of the moot come with a kind of, in a nutshell, this is what the case is about. So they try to frame it in a way which I think is one of the most important skills. The other skill which I always try to teach my students is you have to think commercially. It is, yes, there is a legal dispute there, but underlying there's always something commercial. And in the end, whether you pursue or whether you bring an action, whether you pursue an action, whether you settle whatever, it's in the end a commercial decision. And you have to reevaluate that. And that is something you should also try to put in, have a basic understanding, if you want to do commercial law, about how a company is run and what are the relevant trigger points in a company and how you present that. So I think you cannot be a successful commercial lawyer without having an interest in commercial relationships and understanding of how companies run.
I think these are all great points. I can personally very much relate to Claudia's comment on preparation for a case, for oral and written advocacy. Preparation is everything, and you build up your also position in the team by knowing the case well and preparing the submission and in particular the hearing just as good as possible. It might look in the end just very natural, but it rarely is.
And Stefan, I'll just add an additional point on that. I mean, so many people in developing their career on international arbitration can get very, very narrow and thinking there's some sort of magic path from point A to point B. But the reality is there's so many different ways to get an interesting career and so many ways to pursue a career in international arbitration. I would just urge everyone to not be so narrow, because there's a lot of interesting aspects in international work. And so you want to be open to opportunities that might arise. Certainly, as I was describing my background briefly, I feel like I'm a testament to that. And as I meet so many different people, one of the common themes I see among people who do have successful careers in international arbitration is they have often taken big leaps in ways that would surprise you. There's lots of different ways in which one can pursue careers, and I think the real common theme is you don't need to follow the path of others. You really have to take some leaps and figure out what's going to work for you, because there's lots of different definitions of success.
So there is no magical path. Work hard and have an open mind. That is great advice and very proper closing remarks. Thank you so much to both of you, Claudia and Stefan. This has been an absolute pleasure, and I'm quite confident that your thoughts, ideas, and insights will be interesting and helpful for anybody who wishes to have a career in international arbitration.
Thank you for joining us for today's episode of WolfTie's Soundshot. For more information, you can contact us via email at soundshot@wolfties.com or visit our website at www.wolfties.com.